Pleases the court, my name is Wood, initial K, and I appear with my learned junior Page, initial A, for the defendant, the Midnight Garden, on this matter. Your Honour, there are no Good Samaritan laws. There is, however, an expectation to take reasonable care to avoid harm to others. This has been well established. However, this does not mean any and all actions should or could be taken to avoid harm coming to another. Negligent actions have developed as a way to protect people and not to impose unreasonable or unnecessary duty. Your Honour, the plaintiff claims negligent actions on the part of the defendant that have resulted in physical injury and future economic loss. Counsel for the defendant refutes these claims on the basis of 4 submissions. Submission 1. The defendant's conduct on the night in question was sufficient, and no special relationship existed between the parties. Therefore, the plaintiff is not owed a duty of care under Section 9 of the Civil Liabilities Act 2003. Submission 2. The defendant exercised reasonable care towards the plaintiff, which does not amount to a breach of duty of care under Section 10 of the Civil Liabilities Act 2003. Submission 3. A lack of security personnel on the night in question may not have prevented anything, which therefore would not amount to factual causation under Section 11 of the Civil Liabilities Act. Submission 4. The cause of injury was an uncontrollable incident carried out by a third party and was not due to the omissions of the defendant under Section 15 of the Civil Liabilities Act 2003. I will be addressing submissions 1 and 2, and my learned junior will be addressing submissions 2 and 3. I will now begin with submission 1. Counsel does concede the claim that the defendant owed a duty to take reasonable care towards rowdy and intoxicated patrons. It is refuted, however, that the plaintiff was owed anything more than general duty of care of that of occupier and occupiee. The defendant's actions on the night in question were reasonable and do not constitute a lack of duty of care under Section 9 of the Civil Liabilities Act. These actions were reasonable towards the defendant by way of immediate intervention after the initial incident, followed by the immediate ejection of the offenders from the premises. Counsel submits that a mere intoxication of other patrons doesn't require their immediate removal from the premises. This is held in the case of TAB versus Atlas 2004 and Wagstaff versus Haslam 2007. The plaintiff also claims that there was a duty to prevent criminal injury. Counsel submits that there was no special relationship that existed there, and therefore is no duty to prevent harm from a third party. In Modbury Triangle Shopping Centre versus Ansell 2000, it was held that as an occupier and owner of the land, no special relationship requires a duty to prevent third parties from criminal injuries on their premises. Counsel submits that the plaintiff should have exercised more care in their own conduct, as no action on the part of the defendant exposed them to harm. In Rudy Hill RSL Club 2009, it was held that liability existed in part due to a company policy requiring all members of an altercation to leave the premises, thus exposing the victim to risk. No such demands are made of the plaintiff, and he could have remained safely inside. I'll now move on to submission 2. Counsel submits that the defendant did not breach duty of care as they did not act in a negligent way in their conduct towards the defendant under Section 10 of the CLA, further supported by the case of TAB versus Atlas 2004. The plaintiff has claimed breach of duty of care in the defendant not ensuring the attackers had left the premises and by not walking them to his car. Counsel submits that given the circumstances, the actions taken were that of a reasonable person and does not constitute a breach of duty of care under Section 10 of the CLA. In Edels Palace versus Movark 2009, it was discussed that when considering a breach of duty of care, even if there was a risk, and even if that risk was not insignificant, the determination is based on what a reasonable person would have done. As the defendant's actions were that of a reasonable person that would have been taken in the circumstances, there can be no breach of duty of care. Counsel also submits that the injury was not caused by the defendant, but a third party of which the defendant could have no control over. In Packer v. Tall Ship Sailing Cruises Australia 2015, it was held that crew members on the ship had no way of knowing that the attackers would become violent and therefore were not required to act as such. Similarly, the defendant had no way of knowing the attackers would return and therefore be able to prevent any assault from occurring. Therefore, no breach of duty can have occurred. My learned junior will now proceed to address submissions 3 and 4. Thank you.